It's only for this hearing only. That doesn't mean you have a public defender here on throughout your case. So please don't call their office and say you got appointed a public defender. That's a whole separate process. But for this hearing, I'm going to go ahead and do that. I have come in, I've read the police reports. That's all I have to go on to decide whether the state has probable cause to hold you. So I'll call you up. I'll tell you what your charges are. I'll tell you whether I find probable cause or not. And I'll tell you what your bond amount is. I have pretrial release in here. They have gone in and talked to everybody in there, I believe, or whoever wanted to talk to them. If they want to accept you into their program, they'll stand up here and let me know. So please don't everybody stand up and say, I want pretrial release. That's not the way it's going to work. If you're here on a misdemeanor, we can go ahead and resolve your case on some of them. I'll let you know what the plea offer is ahead of time. You can decide whether you want to give up all your rights and resolve your case today. If you're here on a felony, there will be no plea offers. And if you're here on a violation of probation, I'll try and give you the court date and the judge who you're going to see as soon as you can. Michelle Purvis.
She's in North Broward, Your Honor.
Good morning, sir. How are you today? I don't know your name. I'm sorry. The public defender. I don't know his name.
It's Hector Romero.
Okay. Hi, Ms. Purvis. Can you hear me?
You need to turn the mic on.
Good morning. Can you hear me?
Still can't hear you.
Good morning. Okay. I can't do sign language, so we might have to wait a little bit. Okay, I'm going to try and come back to Ms. Purvis. That's what I used to do to my TV. I used to hit it when it didn't work. I don't know if that's going to work. All right, I'll come back. Ms. Purvis, I'll be back with you if you can hear me. What do you have, sir? Is there something I can get to? Okay. I don't know what I have to dig them out. I don't know. How many you got? 5?
Yes.
Do you know?
Yeah, I know. I mean, I give the names.
Tell me the names.
The first one's Tiffany Mock.
Okay.
The second one's Kendrick Lemon.
All right, hold on. Okay. Let me see the other one.
The third one is Naeem Barnes.
Okay.
Peter Bellany.
Bellamy, you said, sir?
Bellany, B-E-L-O-N-Y.
I remember him farther down. That's not a felony. He doesn't have a felony attached, does he?
He has a felony VOP pretrial violation.
Well,
MO.
we're not going to be able to resolve that anyway.
Okay, no worries, Judge.
What else is your last one? That's 4.
Quincy White. Quincy White. Let me double check.
Yes, he does.
Okay, so yeah.
Okay.
So if the court wanted, I can run up to Judge Poor because I
No
got
worries.
8:30 there, and I
Go
come
ahead.
back and we can knock them out. Thank you, Judge.
Okay. Did you say Miss Martinez is also over at North? Okay. I get you to sit in the audience, sir, unless you have a case?
We're going to need another judge. Desiree Remington.
Well, I'm not going to call it now. We'll try and get another judge down here. We'll let you know. We'll do our best. I said I'll do my best.
Okay. You going to call me or?
I said I would.
Oh, great, thank you.
Grecia. Oh, don't tell me yours is not working either.
Can't hear you, Hector.
Okay.
Can you hear us?
Don't get frustrated yet. We're working on it.
Can you hear us? Yes. We can't hear you.
Why don't you call over there and tell him we've called somebody? He looks.
Well, it's going to be one of the first cases. So where's the doc? Oh, that's the DV. Is Russia the DV? Is that his name, Mark? I thought Brian was the one that fixed it.
Somebody just came on.
You got North Broward?
I think so.
Can you hear Conti?
Yes. Yes.
Hear me like when I turn my head.
All right, we'll be with you very shortly, okay? Give me 1 second. I'm not going to turn it off because I don't want anything to happen.
He can do. There's nothing the judge can do. It's on our end. It's just being difficult.
Are we good now, sir? You can hear me? You can't hear me?
I can hear you. I can hear you. Yes, Judge.
And I can hear you. Yes.
Oh, system's working.
Perfect. All right, Miss Purvis. Good morning, miss.
Good morning.
You're charged in count 1 with resisting or obstructing an officer without violence, and count 2 is a municipal ordinance violation for sleeping in public. I do find probable cause. Your bond on count 1 is $100. If you wanted to resolve your case, I would offer you an adjudication, 3 days in the Broward County Jail, credit for any time you served. I do have to charge a $50 criminal justice surcharge. I would give you 180 days to pay that. Either that or you can bond out and come back for your case for $100. What would you like?
I have no money, so I'd rather solve it.
You think that's in your own best interest?
I guess.
Well, no, I don't want you to guess. You're the only one who knows.
Well, I really don't feel like staying in jail, but
I understand that. What would you like to do, miss?
so what are you saying? I'll be here for 3 days?
You get credit for the day you've been in already.
Right. I guess I'll do that.
All right. I know you use the word "I guess" a lot. I can't let you guess, so you got to tell me. Do you want to accept the plea and finish with your case today?
Right. Yeah,
You think it's in your own best interest?
I believe.
Do you Oh, you changed it to believe, and you think that's better than guess? I'm listening to you, miss.
Yes.
Okay. So what would you like to do?
Well, if I just take the two more days, that will be it with it.
Yes.
And but if I don't, then I'll have to sit here for another court date.
You can until your court date comes, or you can bond out for $100.
Yeah, I don't have the $100.
All right, we'll start over again. Would you like to accept a plea, or do you want to bond out?
Yes, I'll accept
Okay. So you understand all the rights you're giving up?
Yes.
You think it's in your own best interest to do this?
Yeah.
And what do you plead, miss? Guilty, not guilty, or no contest? In your own best interest.
No contest.
I'll accept your plea. Ms. Purvis. Count 1 and 2 be an adjudication, 3 days to run concurrent and coterminous, $50 cost of prosecution, 180 days to pay. Good luck to you, miss. They're telling me you'll be out tomorrow, but I don't know who that was or if they're really in charge. Is that right? Okay. Jasmine Amelia Grecia. Okay. Good morning, miss.
Good morning.
This was it says a domestic violence case. I don't know if it got here by accident.
I think it was just during the booking process, it got missed.
wrong, and she was brought here in error, but since she's here.
Okay. You're charging count 1, touch or strike, battery, domestic violence. I find probable cause. I'm going to set your bond at $500. You're to have no victim contact. Good luck to you, miss.
Judge, one quick request.
You know I did.
Can you send a photo with her?
Sure. I'll be glad to sign one. Bianca Isabella Martinez. I think that's what happened. I thought I was supposed to be there. Good morning, miss.
Good morning.
Let me move all this out of the way for you. You're charged with 3 warrants missed, 3 cases that you missed. I find probable cause based on those warrants. You're going to have to see a judge. They're setting your case for June 12th at 2 o'clock. You're going to see that judge that has all 3 of your cases, okay?
Ms. Martinez had asked me, Judge, if you would consider resolving these matters for her this morning.
Not only because there's 3 of them, respectfully not.
Okay.
Okay?
All right. Good luck, man.
All right, miss.
Okay.
Orlande Clesador. Okay. Hi, Ms. Clesador. You're charged with aggravated battery causing great bodily harm or disability. I find probable cause. I'm setting your bond at $5,000, miss. You're to have no victim contact.
Your Honor, Ms. Clesador has been living here in Florida for more than 20 years. She has family and friends here, including her mother, her sister. She has a friend who she thinks will be able to bond her out. She's willing to stay away from any of the individuals involved in this case. She does not have an extensive criminal history. From what I understand, I think she said she had a theft charge from Dade County several years ago that was dropped.
Okay.
She works at the Home
Respectfully,
Depot.
Mr. Reedy, the pretrial, did you talk to her?
No, Your Honor, based on the charge, we did not.
Okay. I don't think based on the charge either. I think the bond is fair, so I'll respectfully deny that. I'm not going to hear bond motions on every case, sir, respectfully. Taisha LaPorche Hunter. Okay. Hi, miss. You're charging count 1, resisting or obstructing a police officer without violence. Count 2, driving while license suspended. Count 3, unlawful speed in a school zone. Count 4 is a violation of probation, a felony. Count 5 is a violation of community control or probation. I find probable cause. Your bond on count 1 is 100. You have a no bond hold from Judge Cohen. You will be seeing him on June 12th at 9:45 a.m. Good luck to you, miss. Desiree Lee Remington.
North Broward.
That's Mr. Jellen's client, Your Honor.
Oh, it is.
Yes, sir.
Okay. All right, miss, I'm going to have to put you on recall for a moment. Deputy, please hold on to her. I have to bring in another judge to do this, and I have to set aside a time to get another judge down here. So if you can hold on, I'd appreciate it.
No problem.
All right?
Sell to your lawyer, gets here in another judge.
Let me see if I can get a hold of my JA soon. Meryl Lisa Deeren.
North Broward again. Come on, Darren. Darren, I just woke you up. Please, pay attention. Go ahead, stand right here.
Good morning, Miss Deeren. How are you?
I'm okay.
You're charged with a violation of probation, miss. That's from Judge Lynch. That's based on a warrant. I find probable cause. There's a no bond hold on you, miss. You'll be seeing Judge Lynch on June 14th, which is a week from tomorrow, okay? At 9 a.m. Good luck to you.
Thank you.
Alexis Marie Duskin.
That's North Broward again, Your
Okay?
We forgot, we
She
skipped,
bond,
Miss
mom
Mock,
posted.
Miss who?
Tiffany Mock.
Yeah, well, she's got a lawyer. I'm waiting for him to come back. You might not have heard that. It was when the sound was off.
Okay.
Alexis Marie Duskin. Hi, Miss Duskin. Miss your charge in count 1, possession of heroin. Count 2, possession of cocaine. Count 3, possession of Xanax. I find probable cause. Your bond on each count is $1,000, miss. You can bond out for $3,000. Good luck to you. Isha Smith.
Miss Isha Smith is here at the main church. She is the coach.
Okay. Hi, Ms. Smith, you're charged in count 1 with burglary of an unoccupied dwelling while unarmed. Count 2, grand theft. Those are based on warrants. I find probable cause. The first one was originally a no bond hold. I'm setting that bond at $5,000. Your other bond is $1,000. You can bond out for $6,000, miss.
Your Honor, Nicole Hamukos, on behalf of the state, states requesting no return to the residence.
I've never heard no return to the residence. Does she live there?
One moment, please, Your Honor.
Okay. I've heard no contact with the victim, but
No, she doesn't. We're requesting then no victim contact, Judge.
no victim contact.
Judge, respectfully, I do understand this, and speaking Ms. Smith, my understanding is this is her first arrest ever. She goes to Boyd Anderson, she's set to graduate next month. She lives with her grandmother, who's retired on a fixed income. Considering this is her first offense as far as an adult, Judge, and she has a 3.0 GPA.
Well, see, you got me with as far as an adult. That changes the whole story.
I gotta be honest.
Well, I appreciate that, but that makes me stop for a second and think about it. So, pre-trial, did you have a chance to speak with her?
Your Honor, based on this burglary dwelling regarding Ms. Smith, we don't make recommendations
Okay.
for burglary dwelling.
Okay.
Some of the charges, Judge, that appear, like domestics or burglaries like this, pre-trial, they're automatically disqualified. So
Okay.
they're not gonna stand up.
Okay. Can I see? Okay, hold on, I got it. Respectfully, sir, these are capias's warrants, so respectfully, no, I'm not going to change it. It's $6,000.
Yes, Judge.
All right?
Good luck, man.
And I can't check her juvenile record, so respectfully not. Brianna Lee Martin,
North Broward, Judge.
but you're doing your job, sir, and I appreciate that. Miss Martin, you're charged in count 1, possession of heroin. Count 2, possession of methamphetamine. Count 3, possession of drug paraphernalia. I find probable cause. Your bond on count 1 is $1,000. Your bond on count 2 is $1,000. Your bond on count 3 is $100. You can bond out for $2,100. I don't know how to ask this, miss, but it says that you may be 6 months pregnant. Are they giving you good care in there, at least for now? That's what I was concerned about.
Yeah,
Okay. You gonna be able to bond out?
I should be, yeah.
Okay. All right. Good luck to you, miss.
Thank you.
Marie Dulcio.
Ms. Tokyo, come on up, ma'am.
Hi, Ms. Dulcio. You're charged in count 1, possessing or receiving, retaining stolen credit, debit card, fraudulent misrepresentation. I find probable cause. These are warrants signed by Judge Merrigan. The bond on count 1 is $1,000. The bond on count 2 is $1,000. You'll go see Judge Merrigan.
Thank you.
All right, I'm going to stop for 1 minute. I got to try and make a phone call. Hold on.
I don't know the name, but we're going to find out from Mr. Romero right now, I would imagine.
¿Quién habla español? Solamente español. We have several people here who understand.
All right, I'm going to swear him in while you're bringing him up. You solemnly swear to tell the truth, the whole truth, nothing but the truth?
I do.
Tell us your name.
Martín Vidó.
Do you solemnly swear to translate from English to Spanish, Spanish to English, all the proceedings to be had before you, provide an accurate translation to the best of your ability?
I do.
Okay. Name, sir, please.
Nombre, caballero.
Francie Lopez, Judge.
Here you
Francie
go, Brian, right
Lopez
here.
Hernandez,
Judge
case
Diaz
20.
says they'll have another judge here at 10:30.
All right, Mr. Lopez Hernandez. You're
acuerdo.
charging count 1 with a grand theft. I find probable cause. Your bond is $1,000, sir. You can bond out for that amount.
De acuerdo, señor Hernández. Se le acusa en el primer cargo de hurto mayor. Hallo de que hay fundamento de hechos para el cargo. Su fianza es de $1,000 y con eso, prestando esa fianza, podrá salir.
Thank you, sir.
Gracias, señor.
¿Quién más habla español? Come on up, come on up. ¿Qué es tu nombre? Raúl Lopez. Raúl Lopez.
Okay.
He's the next one.
Oh, right now.
Mr. Lopez, you're charged in count 1. You want to translate, sir, or you want to do the whole thing?
Señor López, en el primer cargo se le acusa
Grand theft.
de hurto mayor.
I find probable cause.
Fallo que hay fundamento de hechos para el cargo.
Your bond is $1,000.
Su fianza son $1,000.
I find probable cause,
Fallo que hay fundamento de hechos.
and your bond is set at $1,000, sir. You can bond out for that amount.
Y la fianza se la fijo a $1,000. Prestando esa fianza puede salir. Thank you.
Anybody else, sir?
What for? ¿Qué es tu nombre? Francisco Aparicio. Francisco Aparicio.
Okay.
Try and locate for you, Judge.
I got him.
Ya
Don't
lo
worry.
vi.
Thank you. Mr. Aparicio,
Señor Aparicio,
you're charged in count 1
se le acusa en el primer cargo
with a touch or strike battery.
de agresión mediante haber tocado o haberle pegado.
Count 2 is resisting a police officer without violence.
El segundo cargo es resistir a un oficial del orden público sin violencia.
I find probable cause.
Fallo que hay fundamento de hechos para el cargo.
I'm setting your bond on count 1 at $5,000.
Estoy fijando su fianza en el primer cargo a $5,000.
Your bond on count 2 is $500.
En el segundo cargo su fianza serán
You can
$500.
bond out for $5,500.
Y por $5,500 podrá salir bajo
You're to
fianza.
have no victim contact.
No hay de tener ningún contacto con la víctima.
Understand?
¿Entendido?
Okay, thank you.
De acuerdo, gracias.
¿Quién más habla español? Solamente español. Judge, we're done here with
Thank you.
people that
Thank you,
Your Honor,
sir.
thank you very much.
Kendrick Lemon. Kendrick Lemon, it's a little out of order. Okay. Hi, Mr. Lemon. You're charging count 1. There's a warrant out for you, sir, for an open container violation. I find probable cause. Your bond is $50. Your
Judge, we-
lawyer is here representing you. Yes, sir?
I'm sorry, Judge, we seek appointment and asked if the court will be willing to offer a withhold in this matter.
Well, I was going to offer him an adjudication time served. That would be my plea offer.
Did you hear that, Mr. Lemon? You understand it's also going to include adjudication?
That means a conviction, sir, instead of a withheld. It means an adjudication means a conviction. So if they've asked you if you've ever been convicted of a misdemeanor, even though it's a second-degree misdemeanor, you'd have to say yes. Okay, so what, do I appoint you and then?
Yes, seek appointment, and then he conduct the plea, Judge.
All right, I'll appoint the city
Mr.
public
McLaurin,
defender
I'm sorry, law firm.
to represent Mr. Lemon. Can you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Tell us your name. You can put your hand down. Did you understand all the rights they read you on that video before, sir?
Yes.
You have any questions you want to ask your attorney who I just appointed about any of the rights you're giving up or anything we're doing?
Yeah, when do I get up?
Today? I'll answer that one for you. Might take 8 hours, but it'll be today.
All right, that's perfect.
You have any other questions for your lawyer?
No, sir.
Are you satisfied with his services, or you need to talk to him some more?
No, he's good. He's perfect.
Okay. You understand if you're not a citizen of the United States, by accepting this plea, you may be subject to deportation?
Yes.
Have you had any alcohol in the last 48 hours?
No.
Any drugs or medication?
No.
Have you ever been under the care of a psychologist or psychiatrist?
No.
Are you doing this freely and voluntarily?
Yes.
Anybody promise you anything or force you to get you to do it?
No.
You stipulate to a factual basis, sir?
Yes, Your Honor.
And what do you plead, Mr. Lemon? Guilty, not guilty, or no contest?
No contest.
I'll accept your plea. I'll find there's a factual basis. You're alert, you're intelligent, you understand the nature of the charges, you understand all the rights you're giving up. You're satisfied with your lawyer, and you're doing it freely and voluntarily. On 173993 MO10, I'll adjudicate you guilty. Time served, $50 cost of prosecution, 180 days to pay. Good luck to you, sir.
Thank you, Your Honor.
Okay. And your last one is Barnes?
Actually, no, I have, there technically is three
Tiffany
more, but I
Mock,
want to back
right.
up one. I think you've already called Miss Mock.
I haven't. Naeem Barnes.
He's here present, Judge. May?
Okay. Are you appointed, or you want to be?
On all these, Judge, I'm going to be seeking appointment. Well, I'm sorry. Let me be more clear. On the cases that I called today, Mr. McLaurin's law firm will be seeking appointment. On Mr. Barnes' case, we're only seeking appointment on the sleeping on the municipal beach, not the TC.
Well, okay, I'm not going to appoint you on this one, respectfully, sir. Okay, and let me see what, unless he wants to go to trial. All right, Mr. David, Mr. Barnes, you got 2 warrants out for you. One is a traffic warrant. That's with the state of Florida. They have a bond on you of $500. The other one is a misdemeanor municipal ordinance violation, sleeping on the beach. That's actually in my division. If you wanted to enter a plea on both cases, I'd offer you an adjudication, 5 days in the Broward County Jail, concurrent and coterminous, meaning it all runs together. $50 cost of prosecution on each one. I'd give you 180 days to pay that. Are you interested in that, or do you want to go to trial? You want to bond out? You want to hire the lawyer here, or what do you want to do?
I can just resolve it.
You can.
I'll resolve it.
You understand all the rights you're giving up?
Yes, sir.
What do you plead on both cases, sir? Guilty, not guilty, or no contest?
Guilty.
I accept your plea on Mr. Barnes, case number 1710643, TC 40. I'll adjudicate you guilty, 5 days, credit for any time served, $50 cost of prosecution, 180 days to pay. And on 149172 MO10, I'll adjudicate you guilty, time 5 days, $50 cost of prosecution, 180 days to pay. That's to run concurrent and coterminous. Good luck to you, sir.
Thank you, Judge. And Judge, just to be
Tiffany
clear,
Mock,
Yes.
were we having trouble finding her?
No, she was called earlier when we had trouble with the sound
North
system.
Broward?
Yes, she's in North Broward.
Right.
and Judge, before you start with Ms. Mock, just to be clear, on behalf of Mr. McLaurin, I am aware that he did send a letter to Chief Judge Weinstein maybe about a week or two ago concerning the issue of whether or not the county court judges, pursuant to case law, should be declining to appoint his law firm based on these clients being arrested with municipal ordinance violations.
Okay.
I know they had discussions. I
Do you
don't
know
wanna
the result of them? Because I haven't heard anything.
Well, I read the case law, but I don't want to make a substantive analysis here. Okay. But I would, just in all candor to the court, they are entitled to counsel, to my understanding.
Sure. I don't have a problem with that.
But
I just
again,
thought it was going to be resolved.
But that's not the standard from my understanding. But
no worries.
Just being
What do you
clear
want to
for the
be
record.
appointed on here, sir? I'll see if she wants to
Uh,
accept the appointment. They have to accept, right?
Well, if they're determined to be indigent, Your Honor, then the court can then appoint. Now, if they refuse to seek appointment, then of course they can represent themselves.
Okay.
But then we get into the standard or whether or not they want to, you know, they're capable and competent of handling the case themselves, pro se. But it can't.
It's a lot more than I want to get into today.
Exactly right.
Okay.
And just this again, not related to Ms. Mark. The problem kind of persists because what will generally happen is the courts will just give an offer,
Right.
not allowing them to understand that they are entitled to counsel.
Right.
So the offer would come before advising them that they're entitled to counsel.
All right, and do you know the municipal case that she's here on, what she's charged with? Is that possession of
Yes,
paraphernalia?
it's just the case number 174009 MO10A.
Okay, miss, you got a few charges here. I'm going to read them to you, okay? And I need you to listen because I'm going to have to ask you a question at the end. You charge in count 1, possession of a controlled substance without a prescription. Count 2, possession of a controlled substance without a prescription. Count 3, possession of drug paraphernalia. Count 4 is failing to obey a police officer. That's the charges you just got picked up on. Now, there's a warrant out for you on a sleeping possession of drug paraphernalia, which was in front of Judge Levy. Do you want to accept this gentleman, and I hope you can see him on the camera there, do you want to accept him as your lawyer only on the possession of the drug paraphernalia case?
Why am I not just taking them for all of it? Why?
Because
Doesn't it all go?
no, because that's a separate case. That's a city violation. The other one's going to be state. But before we even get to that, state, I got a couple of questions about this case. Yeah, I'm going to.
Hang on, Miss Mock. Hang
you
on
hold
just one
on?
second. Miss Mock, just hang on 1 second, all right?
You have public defenders appointed to represent you already on that, so let's go slow. On count 1 and 2, which is possession of a controlled substance without a prescription, state, I read that probable cause affidavit 3 times. Maybe I missed something. Is there anything about any drugs they found on her?
We have 1 moment, please, Your Honor.
Yeah, because I read it 3 times and I didn't find anything.
The affidavit mentions that there was a substance that tested positive for cocaine residue, Judge.
Where?
On page 2 of the affidavit at the very end.
Okay, but she's charged with possession of a controlled substance without a prescription, which I'm thinking is some kind of pill or something. I didn't see anything.
Yeah, that was just, Eric Linder, I have to say, that was just the only mention regarding drugs, Your Honor. That's, I understand what the court said.
Then I don't even see a possession of cocaine charge on here.
No.
All right. So I'm going to find no probable cause on counts 1 and 2. State, I'll give you 48 hours to perfect. As to count 3, 4, the only thing left now is counts 3, which is the drug paraphernalia, count 4, which is the failing to obey a police officer, and count 5, which is the other warrant.
Obeying a police officer.
Failure to obey.
Ms. Mock, I suggest you don't say anything at this point, all right?
Here's what I'm going to do. Your bond, miss, because we can't sort this out right now. Somebody needs to speak with you. I don't think it's good to just be talking about it here and resolving it. I don't know what's going on with the case. I only know what I got in front of me. So I'm going to find probable cause on counts 3, 4, and 5. I'm going to appoint Mr. McLawrence's firm to represent you on the ordinance case. All right, so your bond, miss, is going to be $375, I believe. All right, $375.
That's an ROR on 1 and 2, Judge?
Yeah, I'm going to ROR on 1 and 2. And you're going to need to contact this gentleman's firm.
We'll reach out to her, Your Honor.
All right, he's going to reach out to you. All right? Good luck to you, miss. Sorry about all the confusion.
Since you're RORing, we're not going to come back in 48 hours.
Right.
Okay.
Okay. William Lurcock. Okay. Mr. Lurcock, we meet again. Yes.
Just FYI, these
Right.
And only on count 7, he was in custody when the KPS was issued.
Okay. All right, the other case, which was from yesterday. Mr. Lurcock, remember we were here yesterday at ROR'd you on those other charges? That was for a grand theft, operating without a valid license, and driving on the wrong side of the road because they didn't file it, okay? Now I guess they filed new charges, additional charges. And those are warrants, I guess, that they found for possession of cannabis, driving while license suspended, unlawful tag or sticker attached, and possession of cannabis less than 20 grams. Those are from county court judges. I do find probable cause. So your bond now, this is not the case from yesterday, not the grand theft. This is new cases, or actually they're old cases because they're warrants. 500 count 4, 500 count 5, 50 count 6, 500 count 7. So your bond is $1,550.
May I be able to settle this now?
Respectfully not, sir. You're going to have to see those judges. I'm sorry. It might affect your driver's license with the cannabis and the driving license suspended. So I'm not going to resolve those today. I'm sorry. All right? You'll see those judges. Malik, Trevon, Dohawk.
Is here present Judge at Maine?
Good morning, sir. You're charged in count 1, operating without a valid license. Then there's a 2 warrants out for you for petty theft and another operating without a valid license. I find probable cause. Your bond is $25, count 1, 500, count 2, 2,000, count 3. I'm going to look at your driving record, sir, see if maybe we can resolve at least 2 of these. I can't resolve the cannabis charge. I'm sorry. I may be able to resolve them all. Let me look. Sir, if you want to resolve all 3 of your cases, which is 2 operating without and 1 petty theft, I'd offer you an adjudication 5 days on each one, all to run together.
5 days on each one.
Yep. I'm sorry, I should be more polite. Yes, sir? Yes. You don't want to do that?
Is it 5 days for each one, total 15, or 5 days?
No, 5 days together.
Oh, okay.
Total.
Concur.
Okay, yeah.
Let him know.
You want to do that?
Yeah,
Okay, you understand all the rights you're giving up on all 3 cases?
yes,
What do you plead, sir? Guilty, not guilty, or no contest?
guilty.
I'll accept your plea on Mr. Dohawk. First case, I'm going to adjudicate him guilty, 5 days. Credit for any time served, $50 cost of prosecution, 180 days to pay. Case number 163538 MM40. I'll adjudicate him guilty, 5 days. Credit for any time he served to run concurrent and coterminous with a sentence on the first case. And on case number 1569564 TC40, adjudicate him guilty, 5 days. Credit for time served to run concurrent and coterminous with the other cases, $50 cost of prosecution. So you have 180 days to pay $150, sir. All right? Good luck to you. Burden Sainbury.
They're good
Mr. Sabre is here present at Maine.
Sir, you're charged in count 1 with a warrant for a driving while license suspended. I find probable cause. Your bond is $500. Let me see if you can resolve your case, sir, or not.
The judge is going to look into it right now.
You only have 1 other driving while license suspended, sir, so if you want to enter a plea, it'd be an adjudication, 3 days, credit for any time served, $50 cost of prosecution. Are you interested?
Yeah.
All right. You understand all the rights you be giving up?
Yeah.
What do you plead? Guilty, not guilty, or no contest?
No contest.
I'll accept your plea. Mr. Sainbury, case number 1471779 TC20. I'll adjudicate you guilty. 3 days, credit for any time served, $50 cost of prosecution, 180 days to pay. Good luck to you, sir. You still waiting for another one? Which?
Yeah, it's Peter Bellamy.
Okay, let me get to that in a second. I'm sorry. Corey Nicholas Williams. Hi, Mr. Williams. You're charged in count one with possession of cannabis warrant for missing court. I find probable cause. Your bond is $500, sir. All right, you're gonna have to bond out on that. I can't offer you a plea. Good luck to you. Okay? I can't. It's a possession of cannabis. I respectfully not. Okay? It affects your driver's license. Lorenzo Joyette Epps.
Come on up, please. He's here at main judge.
Hi, Mr. Epps. You're charged in count one, resisting or obstructing an officer without violence. Count two, trespass. I find probable cause. Your bond on count one is $100. You can bond out for that amount if you want to enter a plea, be an adjudication, 5 days. Credit for any time you served on both. $50 cost of prosecution. What would you like?
Pardon, sir?
You can bond out for $100, or if you wanted to enter a plea, I would adjudicate you guilty. 5 days in the Broward County Jail on each count to run concurrent, meaning together. $50 cost of prosecution, 180 days to pay. I'd order you not to return to that place.
Bond out.
All right, sir. You can bond out for $100. Jonathan Turhan Marion.
North Broward.
Good morning, Mr. Marion. You're charged in count one with a petty theft, count two, touch or strike battery, count three, committing a theft or resisting a recovery of property. I find probable cause. I'm setting your bond on count one at $500. Your bond on count two is $1,000. Your bond on count three is $500. You can bond out for $2,000, sir. Donald Lee Skinner.
Come on up, please. He's approaching, Judge. He's on
Okay.
the back.
Good morning, Mr. Skinner.
Morning,
You're here on 4 counts of violation of probation. That's with Judge Zeller. She's entered a no bond hold on you, sir. She's going to want to see you. I find probable cause. You'll see her June 8th, which is Thursday at 1:30. You'll be seeing Judge Zeller, okay?
Thank you, Judge.
Good. You're welcome. Lennox Martin LeBlanc. Good morning, Mr. LeBlanc. You're charged in count one, possession of cannabis less than 20 grams. Count two, possession of drug paraphernalia. I find probable cause. Your bond is $100, sir. Respectfully, I don't have a plea to offer you. All right? You can bond out for $100.
I'm asking to resolve it.
I can't do that.
You just said he's not going to talk to cannabis. Good luck, sir.
Justin Martinez.
Mr. Martinez? Yes, sir.
Mr. Martinez, you're charged in count one, trespass on school grounds. I find probable cause. Your bond is $25. You can bond out for that amount if you want to enter a plea, be an adjudication, 3 days, no return to that place, or you can bond out. What would you like?
3 days, sir.
You understand all the rights you're giving up?
Yes, sir.
What do you plead? Guilty, not guilty, or no contest? I'll accept your plea. Mr. Martinez, be an adjudication, 3 days. Credit for any time served, $50 cost of prosecution, no return to that place. Good luck to you, sir.
Yes, sir.
Willie Roy Jones.
Mr. Willie Jones, come on up, please.
Mr. Jones, you're charged in count one with trespass of an unoccupied structure or conveyance. I find probable cause. Your bond is $25. You can bond out for that amount if you want to enter a plea, be an adjudication, 3 days. Credit for any time you serve, $50 cost of prosecution. There would be no return to that place. Are you interested or you want to bond out?
3 days will be fine.
You understand all the rights you're giving up?
Yes.
What do you plead, sir? Guilty, not guilty, or no contest?
No contest.
Accept your plea on Mr. Jones, be an adjudication, 3 days. Credit for any time served, $50 cost of prosecution, no return. Good luck to you, sir. Lorenzo Perry.
Mr. Perry, your present main judge. He's approaching the fine service public defender.
All right, Mr. Perry, you're charged in count one, operating without a valid license. Count two, there's a warrant out for possession of cannabis. I find probable cause. Your bond is $25 on count one, $500 on count two. You can bond out for $525. Okay? Good luck to you. Kevin Taylor?
He's here at main, Judge. I believe he's in the restroom.
I'll hold him. I'll call him again.
Okay.
Elijah Dundas?
Mr. Dundas, come on up, please.
Good morning, sir. You're charging count 1 with a trespass, failing to leave property when ordered by the owner. I find probable cause. Your bond is $25. You can bond out for that amount. If you want to enter a plea, be an adjudication, 3 days. Credit for any time served, $50 cost of prosecution, 180 days to pay that, and no return to that place. Are you interested?
Yes, interested.
3 days? You understand all the rights you're giving up?
Yes, sir.
What do you plead? Guilty, not guilty, or no contest?
Plead guilty. Plead guilty, guilty.
All right, I'll accept your plea. I'll adjudicate you guilty, sends you to 3 days in the Broward County Jail. Credit for any time served, $50 cost of prosecution, no return. All right. Can you tell me who you're looking for and make sure we haven't already called them? I haven't heard that name yet. We'll get to it, okay? Thank you for coming. John Marshall Jordan. Mr. Jordan, you're charged at count 1, driving while license suspended or revoked, failing to register your vehicle. I find probable cause. Your bond is $100 on count 1. I'm looking at your driving record to see if I can offer you a plea, sir. If you want to enter a plea, sir, it won't cause you a 5-year suspension. It would be an adjudication. 3 days, $50 cost of prosecution, 180 days to pay. Would you like to do that?
Would that be for all of the driving suspended, sirs?
I only got 1.
Okay. What was my bond?
$100.
Okay, I'll bond out.
All right, sir. No worries.
Good luck. Thank you.
Roger Joseph Plank.
Mr. Plank, come on up.
Hi, Mr. Plank.
Yes, sir.
Good morning. You're charged at count 1. It's a warrant for a trespass case. I find probable cause. Your bond is $100. You can bond out for $100. If you want to enter a plea, it's an adjudication, 3 days, $50 cost of prosecution, and no return to that place.
Yes.
What do you want to do? Take the plea?
No contest. No contest.
You understand all the rights you're giving up?
Yeah.
What do you plead, sir?
No contest.
I'll accept your plea. I'm Mr. Plank, case number 171912MO40. I'll adjudicate you guilty, 3 days. Credit for time served, $50 cost of prosecution, no return. All that'll be written down for you, sir. Good luck to you.
Okay.
Did we ever get a Chinese interpreter, sir?
We'll have one at 10:30.
Okay. All right, we're now to the felonies. We have Mr. Huang, but the Chinese interpreter won't be here till 10:30.
So 10:30 a.m.?
That's what I heard. I'm relying on Mr. Reedy, so he tells me that. I believe.
And I'm relying on the interpreter's office.
Okay. All right. Now we're starting with the felony, so I'll tell you what the charges are. Roderick Renard Edwards.
Your Honor asked me to remind you, this is the case I provided you with a copy of the affidavit.
Is he here or not?
He's in Paul Ryan.
Okay, I couldn't hear him. Hi, Mr. Edwards.
Yes.
Okay. So, State, you provided me with another probable cause affidavit or a warrant.
I provided the court with the
Let me
warrant.
finish,
Oh,
please.
okay. Yes.
You provided me with a warrant. It has aggravated battery and child abuse. On the PC I have today, it's an add charge of aggravated child abuse. Is there a separation? What are we doing? I'm not sure.
I believe, and if the jail can confirm this, I believe originally on the warrant there was a third count of child abuse that he was not originally booked.
Okay.
under.
Sir Reedy, did he give you a copy to read that?
No. Oh, did you?
Well, he gave you a copy. Did you read it?
Oh, yes and no.
Do you understand what they're doing? Because I still know that I really understand what they're doing. If there's a warrant that says 2 counts on it, you're now filing another PC to add a 3rd count? Is that what it is?
No, Judge, at the time of booking, it was 2 counts of aggravated child abuse, and they only booked it as 1. So they
Okay.
had to put the other charge on them, and that's why.
All right. So has he already had a magistrate hearing on the first 2 counts, the aggravated battery child abuse? Okay. All right. Mr. Edwards, I was just trying to figure out, because they gave me so much other paperwork. You actually have a count of aggravated battery, a count of child abuse, and then you have an aggravated child abuse. That's the new charge today? That's the
That's the same charge, right, sir?
I think it's 2 kids. I don't know. What I'm letting you know is this is a new charge, and I find probable cause, and the bond on count 3 is $25,000.
Can you reduce that?
I respectfully can't, sir. You can see a check with your, the judge who's got your case,
I
though.
mean, that's the same charge, Your Honor.
It is the same one, they just left off. You had a total of 3 charges.
Is it 2 children? Is that what it is? That's what I think I read.
That's correct.
It's 2 children, sir, so they charge you with 1 count on each. They had just left it off before. They're just correcting it. Okay?
So the bond done went up again,
Yes, sir.
and you can't do nothing to lower the bond, because I'm trying to get out of here to get a lawyer.
Okay.
I have a job, I have things to do, sir. I'm an AC technician, and I can't see it. I lose my job right now. I have to get out so I can get a lawyer, and I have to fight.
I understand,
have
sir.
to do.
Somebody in the public defender's office should be in there seeing you soon. Okay?
It's an ad charge for.
Sir, I'm really not going to debate it with you. My job is to just let you know what the charges are. Okay? I don't know anything else about the case. I only read what I read. I don't know if any of that's true. I just know that my job today is to inform you of the charge and let you know what the bond is. Okay? I don't want to argue with you. You've already asked me that twice, and I said no. Okay? All right. Trinard Young?
That last case, we just also request no victim contact.
No victim contact, obviously. Trinard Young?
Mr. Young is approaching. He's here at Main, Judge.
Hi, Mr. Young. You charge and count. These are additional charges. It means it's added charges. Count 11 is robbery with a weapon. Count 12 is wearing a mask while committing a second-degree felony. Count 13 is robbery with a weapon. Count 14 is wearing a mask while committing a second-degree felony. There's a no bond hold on count 12, no bond on 14, and I'm setting no bond on 11 and no bond on 13. All right, sir?
Judge, before you move on from
Yes.
Mr. Young, let me ask the state, is he being held no bond on any other charges at this point?
It appears he's being held on similar charges, and he's got a total bond of $340,000.
Before the court can hold Mr. Young without bond on these charges, it would be the defense's position that the court must conduct an Arthur hearing and make a finding that the proof is evident and the presumption of guilt is great. The state has not come forth with any evidence at this point that could allow the court to reach that very high standard, which is higher standard even than proof beyond a reasonable doubt. All we have this morning, and all I have in front of me actually, is a probable cause affidavit. Probable cause affidavits are designed for one purpose, and that is to establish probable cause, which is a very low legal standard. The state has called no witnesses, introduced no physical evidence. At this point, we would ask the court to conduct an Arthur hearing and to find that the state has failed to establish that proof is evident and the presumption of guilt is great, and set bond for Mr. Young.
Okay, I've read the probable cause affidavit, which is 6 pages. I've read all the facts in there. I think based on what I've read there, I find that the state has met its burden of proof evident presumption great based on what I've read and what I know, and I will deny the motion for Arthur hearing at this time without prejudice.
Thank you, Judge. I'd also point out, according to the probable cause affidavit, the weapon involved was a BB gun,
Okay.
not a semi-automatic weapon.
Okay. Chistelli, Marcus, St. Melis. This is going to be the co-defendant, I believe. All right, Mr. St. Melis, this is count 9, 10, 11, and 12. Count 9 is robbery with a weapon. Count 10, wearing a mask while committing a second-degree felony. Count 11, robbery with a weapon. Count 12, wearing a mask while committing a second-degree felony. I find probable cause. Count 10 is a no bond hold. Count 12 is a no bond hold. Count 9, I'm setting a no bond hold. Count 11, I'm setting a no bond hold. Mr. Reedy?
I believe we're
Same
talking
argument?
about the same probable cause affidavit as in Mr. Trinard Young's case, so I would incorporate those arguments in behalf of Mr. St. Mellis.
And I've read those, and I find proof evident presumption great, and I respectfully deny without prejudice. Juwan Brendan Roper. Aye, Mr. Roper, you're charging count 13, so that means there's other case. You got another case going on. Is grand theft above 300, less than 5,000? Count 14 is petty theft, and count 15 is grand theft. I find probable cause based on the warrants. Your bond on count 13 is 1,000. Your bond on count 14 is 100. Your bond on count 15 is 1,000. So that's an additional 2,100, sir. Good luck to you. Stephen Michael Maher.
Mr. Maher, Judge, I believe he wasn't brought. He was addressed yesterday on this VOP.
Okay, well, he'll see Judge Singal tomorrow. Edwin Gonzalez.
Judge, I've been advised Mr. Gonzalez bonded.
Okay. Hi. Bellany?
Peter Bellany?
Yes.
Coaching. He declined the service as public defender, Judge.
The same for the municipal ordinance case?
Sure. I was just about to do that.
Okay, I'm sorry.
Mr. Bellany?
Yes, sir.
Sir, you're here on two cases. One is a warrant for a felony in front of Judge Singal. I find probable cause on that. He has a no bond hold on you. You'll be seeing Judge Singal soon. It doesn't give me an actual date, but you'll be seeing him. Your other case is a misdemeanor, and there's a warrant out for that. And I have a young lawyer standing in front of me who works as the assistant public defender for the city. Do you want a city public defender to represent you, or do you want to decline those services? What would you like?
I'm going to have a private lawyer, sir.
You're going to get a private lawyer? Okay. So your bond on the misdemeanor is $2,500. There's a no bond in front of Judge Singal, and I guess you'll get a hold of your lawyer. They'll let you know when that hearing is, okay? I don't actually know the time and date yet. All right? Good luck to you.
Judge, I know we skipped Mr. Kevin Taylor because I believe he was out and back to the restroom. He's back, so whenever you're ready, Judge, we can address him.
Bring him up.
We also have the Chinese interpreter.
Okay. Mr. Taylor?
Yes, sir.
Good morning, sir. You're charging count 1, possession of cannabis, count 2, possession of drug paraphernalia. I find probable cause. Your bond is 100 on count 1. You can bond out for that amount. I can't offer you a plea at this time, sir, on a cannabis charge, okay?
Yes, sir.
All right. Good luck to you.
Am I resolving the case?
No, respectfully not. Okay, sorry. We have the Chinese interpreter here. You have a question, sir? For Mr. Huang? You want to come on up, miss? Who's the interpreter? Are you sure, Mr. Heminger, she's the interpreter? She doesn't seem to understand me. No? All right, I'm sorry. They're not here yet. 10:30. Sorry, my bailiff just thought it was. Now I understand. Neverez?
Christopher Neverez is here present, Judge. He declined the service as public defender.
All right, Mr. Neverez, you're charged with aggravated assault with a deadly weapon without intent to kill. I find probable cause. I'm setting your bond at $5,000. You're to have no victim contact, sir.
I understand.
Good luck to you.
Thank you.
Jimmy Kenneth Boney.
Mr. Bond?
Is it Bonnie?
What's up?
Sir, you're charged in count 1, 2, 3, and 4 with violations of probation and community. I'm sorry. Count 1 is a possession of cannabis. I find probable cause. Your bond is $100. In addition to that, you have 3 counts of violation of community control. That's in front of Judge. Hold on.
We have it corrected. It should only be 2 counts of the violation of community control, one being a 94806, and then the actual violation.
All right, so let me see if you can tell it to me this way. Count 2 is a violation of community control on case number 141795. Is that good?
Yes.
All right, case violation of community control 141759 CF10. I guess it's 2 counts, so that's
Right.
good. The
No.
new one, which is 14, you got the extra one. Is that what I need to strike out?
Right, two
Okay.
of them say violation of community control.
Right. All right. And there shouldn't be number 4 either? Possession of cannabis, violation of community control. All right, got it. All right. All right, sir. What were you going to tell me now that I think I got it straight?
This one. By itself.
Well, that's to be determined at trial, sir. I don't know. All right? But there's a no bond hold. You're going to see Judge Usan on June 12th at 9 o'clock, okay? Good luck to you. Andrew Joseph Benito. Mr. Benito, you're charging count 1, 2, and 3 with violation of probation. I find probable cause. There's a no bond hold from Judge Robinson. You'll be seeing him on June 8th. All right? Good luck to you. All right. Ramul Josephat. Good morning, sir. You're charging count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 with receiving or possessing stolen credit card or debit card. Count 16 is fraud, using possessing ID of another without consent. Count 17 is possessing a forged driver's license, and count 18 is possessing a forged driver's license. I find probable cause on all of them. Your bond on each count is $1,000, so your bond is $18,000, sir. You can bond out for that amount. Good luck to you. Sebastian Garcia. All right, Mr. Garcia, you're charged with burglary of an unoccupied structure while unarmed, grand theft, 5,000 or more, but less than 10,000, and criminal mischief over 1,000. I find probable cause. I'm setting bond on count 1 at 5,000. Bond on count 2 is 1,000. Bond on count 3 is 500. You can bond out for 6,500. Good luck to you. Jerome David Moore. Hi, Mr. Moore, you're charged in count 1 with a violation of probation. That's for a warrant from Judge Fine. I find probable cause. There's a no bond hold. You'll see Judge Fine on June 12th at 8:45. Good luck to you. I'm not Judge Fine. You'll have to see Judge Fine. John Robert Coughlin. Good morning. On who? Coughlin. All right, sir. They posted your bond. All right. I find probable cause, but they posted your bond. Sagray Powell.
Mr. Powell, is your present, Judge?
Good morning, Mr. Powell. You charge account 1, grand theft over 300, less than 5,000. I find probable cause. Your bond is $1,000. You can bond out for that amount. Yes.
Judge, as you can see, I limited my speaking in quite a few clients today.
I appreciate it.
Mr. Powell,
I appreciate it.
I've had an opportunity to speak to him, and if the state can verify, my understanding is this is his first arrest ever. He is a single father. He works for DirecTV. He lives with his mother. The only person that can help him bond out is his mom, who does housekeeping. Financially, she's not in a position to post his bond. I'd ask you if you would consider pretrial release if the state can verify. This is his only ever.
Let me ask. I'll ask. Pretrial, did you interview Mr. Powell?
I'm checking to see
Okay.
what we found out about Mr. Powell.
They're going to let me know. And I won't hold the fact that he works for DirecTV against them at all.
We were unable to make a verification on Mr. Powell's behalf. If the court is inclined to release him pending verification, I can, but we're not recommending him because we did not verify.
Okay. All right, sir. How about I do this? I'll release you to pretrial once they verify the information they need. All right, so I'll sign an order to let you out, but you're going to have to report to them as soon as you get out. But they're going to have to verify.
If the court will just write pending verification.
Hold on.
Findings.
I'm sorry, miss?
If you'll please write pending verification and leave the bond.
Sure.
Thank you.
All right, sir. Hopefully they'll get to you today if they can verify that stuff.
And a verification. If you get verified, this is where you go right. That's a match.
Okay. Quincy Aldridge.
Would waive formal reading of the charges, Your Honor.
And Your Honor, just, the state would just ask to be heard before the court sets a bond in this matter.
Okay. All right. Mr. Aldridge, they've asked me not to read the charges. Yes, sir.
Does the court find probable cause?
I do find probable cause
Your Honor,
on Mr. Quincy Aldridge, count 1 and count 2.
Your Honor, the state would argue that Mr. Aldridge presents an extreme danger to not only the alleged victim in this case, but the community, not only based on the allegations contained in this affidavit, Your Honor, but his criminal history. Your Honor, I can tell you 2012, Mr. Aldridge was convicted of failing to report as a sex offender, sentenced to 5-year state prison. Also, in a separate case in 2012, he was convicted of armed burglary of a conveyance, carjacking with a firearm or deadly weapon, robbery with a firearm or deadly weapon, and armed false imprisonment, and sentenced to 5 years state prison on that case also. He was released from state prison July 13th of 2016. A battery in 01, and in 1991, he was convicted of armed kidnapping, sexual battery using weapon or great force, and principal in the first degree. He violated his probation in that matter and was sentenced to 20 years in state prison. Your Honor, state would be requesting $250,000 bonds on counts 1 and 2. Obviously, no victim contact, and should Mr. Aldridge post his bond and be released from custody, that he be supervised by pretrial release services with a GPS monitor level 1.
Mr. Reedy, do you wish to be heard?
Perhaps Mr. Romero might wish to be heard, Judge.
Okay.
Judge, and speaking of Mr. Aldridge, he's been residing here in South Florida his whole life. He just started working. He works for a company that does home improvement. So it's basically construction, making $10 an hour. Financially, he's never had an opportunity to save any money. He has no money in bank. He owns no property. He lives with his mother. They rent a house with his mother and his sister. So they don't own real property. They're renting. Financially, his mom and his sister are the only people that can actually help post his bond, but financially, they're indigent as well. I'd ask you to take that into consideration in determining a reasonable bond in count 1 and 2.
I apologize, Your Honor. The only thing I want to bring to the court's attention, I believe Mr. Aldridge is going to be coming back. There's a third count on the warrant for false imprisonment that BSO did not originally book him under, but I've been advised they are going to book him and add charge him with that.
Okay.
I think the bond that the state is requesting, from what Mr. Romero is indicating to the court, is tantamount to no bond at all. So I think that to set a bond in the amount the state is requesting would be an excessive amount of bond. Mr. Aldridge is presumed to be innocent of these charges. I understand that the court has found probable cause. I also read the warrant, and I understand that. It sounds like maybe a fairly triable case, quite frankly, but I'd ask the court to consider a bond and $25,000 on each count.
Respectfully, having read the probable cause affidavit, in addition to that, having listened to the defendant's priors, respectfully, I find he is a danger to the community. In fact, I'm going to put a no bond hold on count 1 and count 2.
We would object to that, Judge, unless you're making a finding that the presumption of guilt is great and the proof is evident. To hold Mr. Aldridge without bond, you would have to conduct an ARPA hearing at this time, make those appropriate findings, and based on what has been presented to the court here this morning, our position would be that they have not come close to meeting that burden. They've called no witnesses and introduced no evidence at this time. They don't even have a recording of the tape conversation that Mr. Aldridge had with the alleged victim in the case. The court has not heard that. But you haven't heard it.
I've read it.
But you haven't heard it. The state has a very high burden here, Judge, to proof evident presumption great.
Reading it and hearing it.
The state has a very, very high burden here,
Okay.
Judge.
Well, I find proof evident presumption great based on the four corners. I'm gonna no bond him. I think he's a danger to the community.
Judge, just for clarification, I know you heard from my colleague. I don't know if this is a PBL offense. I don't know if the state.
I don't know if it is either, but I'm holding him no bond.
Your Honor, if I may, just for
Judge,
Yes.
it would be over to the defense, Judge.
Of course.
Just so we're clear, Your Honor, under Florida Statute 907.041, is the court finding that you do not believe that there are any conditions of a release
Correct.
that could reasonably protect the community?
Yes.
Thank you, Judge.
All right. Okay, let's move on. Willie Edward Moore.
Judge, I've been advised Mr. Willie Moore is a medical recess.
Okay. Quincy White,
Mr. White, medical reset as well?
okay.
Judge, I've been advised for medical reset.
Okay, thanks. David Patterson.
North Broward.
Hi, Mr. Patterson.
How you doing, sir?
Good. You charged count 1, burglary with an assault or battery. Count 2, resisting or obstructing a police officer with violence. Count 3, probation community control violation. Count 4, there's a warrant for you for a felony. Count 5, a warrant. Count 6 is a violation of probation misdemeanor. I do find probable cause. Count 1.
Your Honor, it's punishable by life offense. The state would be seeking a no bond hold.
Well, there's a no bond hold on it. He's also got a no bond on count 3, 4, 5. He's ROR'd on count 6. Mr. Reedy, would you like to be heard, sir?
No, Your Honor. Since he already has a no bond hold on these cases,
All right.
the defense would defer any argument
All
at this
right,
point.
I'll leave the no bond on count 1 also. Okay. All right, we're waiting for back to the main jail. Mr. Romero,
Yes, Judge.
you have 2 people sitting there.
Mr. Mincy is one of them.
Okay,
Which is the
I don't have a Mincy. Oh, it's a perfection.
Your Honor, I have nothing additional.
All right, they have nothing additional, so he's ROR'd on that.
ROR.
All right. Now, hold on, Miss. So on Miss Remington, her lawyer was here, and we're setting that for 10:30. I have to get another judge to hear it. 10:30. Yes. Where is she?
She's in North Broward, Judge.
All right. I'm sorry, but I have to get another judge in here to hear the case because I don't hear Mr. Jellen's cases. I've arranged for that judge to come down at 10:30. We've called him and let him know that. You did call him, right?
Yes, Judge, I spoke with him.
All right. So just checking. So we will be back at 10:30 to do that, and the interpreter, Chinese interpreter, should be here at 10:30. Sorry, Mr. Romero, we'll have to hold you up a little bit. All right, we'll be in recess till 10:30. Yes. I'm sorry. Let me look. Do you have David Patterson? I'm sorry. I hate to do that. Let me see. Count 2 was $500. Yes.
Yeah, well, I won't.
Okay. Did I go too fast? You all right? All right. Okay, I signed that.
Yeah, now call ITU a bit. And see what's going on with ITU. Okay, so I wrote down. And you know what? I want can I write the statute? The one Eric added the note to. The no bond case? Yeah, the no bond case, and he wrote it on the bottom left in black ink. And it was like the big one, I think, that I stapled and handed to go to SBU. Oh, SBU, sorry. I think, yep, that one. I just want the statute number that he wrote. And SBU, when you guys do it on the weekend, Just write SBU and you can put it with a stack so they know it's SBU and just separate it.
First statute 907.04.
Was it a misdemeanor? Okay, that's what I wanted to think.
Okay. Yeah, just you can, if it's anything that's SBU, DTU, and homicide, make sure you put homicide, put sticky on them and put it with stack so they can do it out.
Dumb question. What goes to each one of those?
For that perfection.
What goes to SBU? What goes
Sex back, and child abuse.
Okay. Let me write this down. Hold on. Let me write this.
Oh,
Okay,
Jesus.
thanks.
This one, wait. Here, child, no mind.
It's two.
Homicide, all murder cases, not attempted murder.
Not attempts. Okay.
Not attempted, all murder cases.
They put it on there.
What about like manslaughter cases?
You can put it, because it depends on things I want you guys to
Miss it.
miss it, just go ahead and then they can separate
He
just
has
in
not
case.
signed.
Because sometimes manslaughter can be something else.
Err on the side of
Anything else?
giving it. Okay.
And then DTU,
No, go ahead.
all trafficking.
So not just possessions.
No possession, just trafficking, any trafficking.
He not gonna come back?
Cocaine, any trafficking cases.
Not intends to sell.
No,
She got a number?
just
Okay.
trafficking.
Thank you.
Patrice, did you still what you need? I'm sorry.
You have his number? 'Cause
Okay.
is he
Another
gonna
question
come
I
back?
had on the weekends, since we don't have NTIC, when they ask
Is
about
he gonna
priors,
come
isn't
back?
there somebody in the
'Cause remember
courtroom
he said
that's
somebody else
giving
was
like the other county priors?
You might have to call her, yeah.
Okay.
Tell him he forgot to sign one for it.
Just in case.
Okay.
That's the third.
I'll only be able to put that.
But I'm just saying if you need the help for the other person. I'm just saying just in case.
Gotcha.
ITU is a really slow.
I see. You could. Okay.
Call
Good
me,
exercise.
and I'll text you my.
Okay.
Okay. But we're supposed to be working on Alpha. I don't know if they're coming.
Yeah.
You know how they are.
Yeah.
So
Will resets be here in a folder or?
I have a reset folder right there.
Okay.
Put any resets, stick them in the resets.
Okay.
Perfections, you know how to do.
Do we have
Yeah.
to get one to go back? Or
You just keep it, start stalking the officers till they give you.
Yeah. Ask for it.
Yeah.
Half the time. Do it. Anything else? Anything else?
Yeah. Where do we take the paperwork after?
Upstairs to Judy.
Who is that?
On the 7th floor by E5, like by
Okay.
our by the red. Seventh floor. Judy.
Okay. Okay. Thanks.
Anything else?
No. I'm gonna get my handy little cheat sheet and add this stuff to it.
Yeah.
Okay. And if something comes up that we're like, what is happening, we call Eric, right?
Yeah, you can bother him.
Yeah.
And a judge.
Yeah.
That's gonna be.
Yeah. Unreal to me.
I think it's better. You're juvenile.
Yeah.
It's just so different in juvenile, so it's hard.
Because we have experience dealing with the felonies.
And you guys are slow paced in
Yeah.
juveniles.
Oh,
They're
yeah.
not- They're not
Very.
like.
Even when we do the detention hearings, there's like maybe 7.
Yeah.
Maybe. On a busy day, there's 7.
Oh, we can't stand. He is very rude to us. He thinks we are. Just really scared because of doesn't want me. He was in the other building. He always comes to ask. lies, and then he come back and say that we lied. He lies. You know that, right? Comes here right middle of court, stands there and says, "My case. This is."
Yeah.
Wait a minute. Excuse me.
Yeah.
That's the kind of person that the white beat the shit out of him, and he has to come and get it up here. And I keep saying, I don't care. It's true.
Devin said, do you want overtime Monday to cover AM and And I said, why not? Sure, I'm Wonder Woman. That's my reply. I think
it'll be fine. It'll be fine.
Yeah.
Just depends on what judge is and stuff, so.
Oh.
Do you have to put it in? Yeah. We do every day. Every now and then.
He's done, I'm done. Only thing I have is the county.
So,
See the way they set up?
did we? Oh, we were on record, I think, a minute ago. I was just about to ask, does he always leave it on record, like until everything is done? Because I thought it was strange, but he's
It's not true.
the light just went off. All right, this is my little cheat sheet. Cheat sheet. Read PCs. George's number.
He crossed out the wrong one. By the way, Danny, your friend John told me. Listen, Jonathan, you know what? You know what you call them don't matter. Child, he put a big old line.
Eric's computer? Yeah. All right, I'm gonna check and see if it works out. I'm gonna. The same. It's the same thing? Okay, I got the password. Let me try it, and if anything, I'll call you back. All right, thanks. Thanks for telling us. Any other questions?
No, I think I'm good. I'm just adding my extra little notes that I took today to my little cheat sheet here.
I went around through the bridge.
Oh,
They need this logo? I wasn't able to, oh, to get to the, okay. I missed you yesterday. Dad, you know somebody put, that note you left me? Did you get a paper copy? Cause there was a paper copy. We did it again, but you gotta actually get up. What's your phone? I got an email. I'm moving tomorrow. Okay. Oh, wait. I gotta go to take this one. You gonna be in here this afternoon? I am. I'm here for the rest of the week. Okay. She ain't. Okay. Oh, that's right. I was going on. Well, whenever you go. There you go. Where's Mr. It's Ryan.
You're done. I don't know. Until you just wait here. No, I don't think I have to wait, right, for the last 1 or 2 years.
Did you get that donut from downstairs?
No, why?
Chinese
Dang, I didn't know there was I'll never do that.
We got radars over here.
No, I didn't have time to eat it this morning, so I just thought, well.
You see these,
Yeah, I think we have a regular docket, so I think I'm gonna go, 'cause then I can handle my own docket. Awesome. Well, appreciate the help, and if anything comes up, everything's ready.
They said I'll let you know. They said we could do it. I'm not gonna log right now.
Yeah.
I'm on it, but
Yeah.
as soon as I log off, if it's the same thing, then we log on. If it's the same thing, I'll stick it here too. So I'll double check it and see
Okay.
for you.
I think it'll be fine.
Yeah. You don't mind if I send you pictures and stuff like ideas?
Oh
and
my
stuff?
God, no, of course not.
And
You have
you
my
send-
cell phone number, so.
If you want to send me some ideas, go
Yeah.
ahead, so that way I can see what I
Yeah,
have.
for sure.
If I need. Your sister's like, or
She's thinking, so she said,
why don't you send me like
Yeah.
ideas and pictures? I mean, I go a lot on Pinterest. So
yeah. Yeah, oh, no. I'll save, once we
If
get
you have
closer,
something, yeah,
I'll
just
start to
even-
save pictures and.
Even
Because it
whatever.
won't be till like February.
Oh, I
next year.
understand, but it takes,
Yeah.
you know, just for if you need, well, the rest of the time, if you need other stuff, so just.
Yeah, I won't wait till like a month before. Be like, oh, please.
No, nobody.
Yeah.
No, I mean, if you do, just go ahead and I'll send you some ideas and you tell me. what you want.
Her actual reception is going to be very kind of like driftwood and orchids and kind of more washed out. But for the shower, I want it's almost kind of like hibiscus would be cool, or like palm leaves, the big like monstera leaves, the palm leaves with all the little nooks and crannies.
There's a new thing that came up people are using. It's for a backdrop. I don't know what backdrop. I'm just looking at it. It's like it looks like a grassy backdrop. And
I've
then
seen, yeah.
And they add the blush flowers.
That could be really cool.
For the backdrop.
Yeah.
That came
And
up
I
new on there
love
actually.
like gloves, like this kind of thing.
If you do, just send me.
If I
Just
get
send me.
service.
Just
I'll
for fun.
send- yeah,
Just
I'll send you pics.
Do me. Just send me things.
Yeah.
And that'd be
For
good like
sure.
that. So that way.
Yeah.
We can work around like ideas and
Yeah,
stuff.
I'll definitely send it to you because that could like make her whole shower having that. You know.
Yeah.
So
Let me know. Let me know.
thanks.
No problem.
Okay. And you're if
And I'll let you
I
know.
wasn't
Yeah,
supposed to
just
go.
tell him.
Yes,
I'll let you know what's gonna happen here.
Okay.
He said it should be logged on, but
Yeah.
I'm glad they, they told me, it's like, yeah, log on. I'm like, okay, but I'm gonna try it out.
Yeah.
And I'll let you know what judge if I find out before you do.
Perfect. Thank you very much.
No problem.
I'll talk to you soon.
All right, bye.
No, the phone's going, that's my only. In case you have stuff going on. I have to walk out.
y'all do know first magistrate be in power. It has not been a no more since we've been here. Jesus.
Hopefully, with the weather, the afternoon dock will be small.
Is it, wait, it's raining out there?
If it's not, it's gonna be. I mean, it's ugly as hell outside. So, what'd you guys do last night? It's like because you don't even remember. Nothing special.
Oh, my mom wanted KFC.
Oh, how did the shrimp turn out Friday night?
Good. My mom wanted KFC. KFC and Taco Bell.
Oh my god. Because especially because what time do you guys usually break?
8:15.
Oh, see, I couldn't do it. I could not eat Taco Bell. Oh no, I'm saying is I'd have indigestion. I wouldn't be able to sleep.
I know.
I'd be eating. You guys are eating. Oh my. Brian Reedy is the PD. Well, no, he'll be here in a minute. Yeah. You've seen Talladega Nights, right?
Mm-hmm.
Talladega Nights. He's a race car driver. Okay. All right. Well, point being is there's a scene in the movie. He's like a hillbilly, like championship race car driver, and like his kids are misbehaving, whatever. So there's a dinner scene, and he has all these sponsors. So what are they eating? Because they're rednecks. So he's like Taco Bell, pizza, like all the literally all the stuff you just had to bring that fast. That's what just you basically had. Yeah. This no, I'll rip them all up. This one we got our own copy. I don't even know what is this. Oh, this is what I told my.
Hey, Mr. Jellin.
All right, I'll put it in the reset.
I don't know.
Let me see. Oh, they didn't even get the DUI. What the hell is all this? No, I'm saying they didn't even get this. They didn't even get this guy. What did she bond out or something?
What is that?
She's not on the second document. Maybe she bonded out. I don't care.
Medical reset.
All right.
And then this is the SBU out. She comes in.
Speaking of which. Hey, it's Eric. Hey, I gotta bring a guy to your attention. This is one of the worst I've seen. Guy's name is Quincy Aldridge. Quincy Aldridge. Okay.
How much more you got?
No, not much. You want me to just give you his BCCN number? 97881. He was arrested. I think you guys can actually might be able to upfile if the victim is cooperative. He was just charged on sexual battery, 2 counts. Victim over 18. He's gonna come back on a 3rd count of false imprisonment. Sending the arrest warrant your way, but in it, there's allegations he choked her, threatened to kill her. So I think you could even consider upfiling to threaten great bodily harm. So, anyways, 1991, armed kidnapping, sexual battery with a weapon or great force, principal in the 1st degree. He violated probation, was sentenced to 20 days. 2012, armed burglary conveyance, carjacking, firearm, deadly weapon, robbery, firearm, deadly weapon, armed false imprisonment, 5-year state prison. He also had a failure of sex offender to report in 2012. He got 5 years on that. He was just released from state prison July of last year. Now, I was asking for $250,000 each on the 2 sex bats with a GPS level 1. Judge Diaz ordered him to be held no bond. Now, at first, the PD and him were going back and forth about proof of the presumption grade, which wasn't going to matter. It's not a PBL this time. But I put on the record, like, Judge, does the court also find under 907.041 that there are no release conditions to ensure the safety of the community? He's like, yes, I do. So that's why I made sure to get that on record in case they do file a writ. That because I was talking to the PD outside after. I'm like, if you guys file a writ, I can't imagine the fourth, not based on this guy's record and these facts, I can't imagine the fourth wouldn't find that reasonable. But that's why I wanted to bring it to your attention, because I mean, just hearing those priors. And they did do, and you'll see in the warrant, what I'll do, here's what I'm going to do. Obviously, we're going to pass our copy of the warrant affidavit along, but it seems like there's some stuff, the printout was screwed up and it missed some stuff. So I had the detective email me another copy of the affidavit. If that one's good, I'll forward that to you. All right? All right. You too. See, you're just going to keep going for the pretzel chip, Chris. Oh, so you're good with Allah. You're good with Allah. That's medical. That's medical necessity. I think our religions are the same. You don't have to fast on your Torah if it's for medical necessity.
I can't not drink. My kidney.
No, you can't be dehydrated, even though you keep drinking coffee, which dehydrates you.
Or I drink like 2 bottles of water after it.
You know how much you and I should be drinking a day? Honestly?
About 6 of them.
No. Literally, a gallon. I was reading this guy saying.
I drink at home.
He was,
Maybe 2 of them at home.
What I was reading? What I was reading is this guy was saying it's like what's ironic is that 95% of the world's population is dehydrated technically and doesn't realize it. He's like, I drink 2 gallons of water a day. And he's like, obviously everyone can't do that. But you should be drinking about a gallon a day to make sure you just pee. You just pee a lot. You spend half your life in the bathroom. Either that or you get a catheter. So Joshua Vincent, assuming he goes okay tomorrow, he's doing his third tomorrow morning.
You're not gonna be here tomorrow?
No, I'll be here in the morning with him. Assuming everything goes okay, he'll do the afternoon by himself with you. I'm sure it's gonna be fine.
I was gonna take Monday off.
Take Monday off.
That guy Jeremy Skinner wants to be here tomorrow Monday. You better come early.
I'll come early.
You come early?
Yeah. Take Monday. Absolutely. Take it.
Because he stopped on Monday. Don't forget, I'm gonna call you.
Because we got trainings like every day, so you might as well.
I know. I was looking at the list.
I know, right? And I got to fill in some too.
Oh my God! I saw at least 25. I think little boys.
Really?
Getting their fingerprinted.
Well, you know, now they got the speculation is that stuff that they were doing. Yeah, why I emailed them yesterday. Yeah. It's not because of Fred. No, I'm saying it's not because Fred helped him. Fred's a hardcore Democrat. You think Rick Scott gives a crap what Fred about Fred?
I think he's good.
Hello?
I'll have it for him.
Hi, Dr. Parrish. It's Eric Linder. Hey, I wanted to call you. I've got a meeting at my building tomorrow afternoon about the building that they're trying to build next door. So I was hoping, if you're not able to now, I was hoping if I could call you later to reschedule for next week. I'm not going to be able to make it tomorrow. So can now, or should I call you later? If you have next Wednesday, that'd be great. I'll see you then. Thank you. He's very close with. He's very close with Steve. They were trial partners.
That's what you're doing, dude.
Just be glad you don't have to deal with representing this guy.
Mr. Kidnapper?
No, Mr.
I would just blame it. I would say, Judge, he's a drug addict.
Mr. Well, here's the problem. You don't know what his new charge is.
I do. Kidnapping.
No, not kid. Well, no. How do you know? Would you see it? No, that's from 1991. No. That's what I was going to say. It just so happens it's the same thing again. The circle is complete. Oh man, don't mess with that.
Some fancy shit.
Oh yeah, very fancy. Do you see where we keep the remote? No.
Yeah, I think that's why it doesn't work right.
Yeah, well, no, because it used to be here. Oh, that was off. This was again, he said to go in there. Except he said stop working on the
You figure with the millions, you're right. This is how they do it.
Yeah, no, that's
Why do they even need that? Why don't they just have a screen on his desk?
That's what adds character in Broward County. That all the millions we still have shit.
But why would they even need that? Why don't they have a monitor on his desk like this? What does that do?
What's
Who's
for the
that?
judge?
Right. Why don't they have a monitor on the judge's desk?
Oh,
What's the difference? This works. Why not just have a monitor on his desk? They
you
figured
know-
they already had they paid for this thing, so why not use it or something?
Well, I think that's because
They should put it right there
I
for the
think
benefit of
that's-
the audience.
I think well, no, that's that.
Oh, okay.
I think that is the internet camera, which lines up to the camera. So because that's
Really quite high.
It's very important. That works, right? We broadcast pirated. That's the funny thing about this.
They just, what happened was when you built it, they were supposed to. So it's just strange. No, there's nothing at all. Next time, nah. Some will get, especially the kind of data we build something. I can do it now. You're welcome. See you later.
Yes, that's true.
He had an intern when so he was just showing her around. And we can just talk.
I said that. Aren't you listening?
Yeah, exactly.
You know, for the private, you know, like.
Are we on? Is this on? Yes. We're on. Okay, so Desiree. Desiree Remington?
North Broward, Your Honor.
Thank you. Okay, Ms. Remington, you have a violation of probation. Your counsel is here. Your VOP hearing is set for June 8th at 8:30 a.m. in front of Judge Robinson, I believe.
Yes, Judge, but I did speak with Ms. Remington. Desiree, you understand that he's going to take himself off the case if I'm the lawyer. You want me to go ahead and take care of that for you?
Yes, please.
Okay, and you want me to address the medical issues or just leave that be until I talk to BSO?
You could just leave it.
Thank you very much. That's it, Judge. Thank you.
Okay, wonderful. Thank you.
All right,
You
have a
want
good
to do this, me to do this one too? My pleasure.
Yes, sir? Okay. The interpreter's not here yet, right? Oh. Okay. Will Mr. Romero be able to explain that to him?
I don't know. Hector, we're not going to have the Chinese interpreter until 1:30.
Okay, I'll try and do my best by showing him a clock. 1:30.
And I
Maybe
believe
you can
that
write it down. Maybe he'll understand it. I don't know.
That I will.
Numbers are pretty universal.
I have.
Okay.
Also, I advise Judge Diaz that our office wished to supplement the record for some more further legal argument on Quincy Aldridge.
Go ahead, sir.
Thank you very much, Judge. Regarding Quincy Aldridge, that was the matter that was handled earlier today. My understanding is Your Honor went ahead and held Mr. Aldridge no bond on both counts. I think from what we all concluded, this isn't a PBL offense. There's two ways a person can be held no bond, and that's one if it's a PBL, so it doesn't qualify under that. The second would be by Rule 3.132, pretrial detention. That's the rule that governs. And as Mr. Lender did state earlier, the offenses that are eligible to be held no bond are referenced in 3.132 under Section 907.041, which talks about dangerous crimes, which at this time the defense will stipulate is what he was arrested for on count 1 and count 2. So that qualifies. Under this section, though, it tells how the court can go about it. I don't think in referencing this section, a court could sua sponte order a person held no bond. It's what has to be done is the state has to move for it, and it talks about how the state goes to move for it. They have to actually present a motion. It's a written motion. And at this hearing, if it would be done at magistrate, if the state were to present this written motion, then Your Honor could hold him no bond upon a showing of probable cause, and he's entitled to a hearing within 5 days in front of his assigned judge. That hearing, he's entitled to counsel. He's allowed to present defense witnesses. He's allowed to cross-examine. He has a whole hearing, and at that hearing, if the state or if the judge agrees with the state at that time, then he could be held no bond. Now, if the state doesn't have a motion today, this statute allows Your Honor, upon a showing of exigent circumstances, and you could do so, record, by a showing of exigent circumstances and a finding of probable cause, you could hold them for 3 days while the state supplements the record with a written motion, and then once the written motion is filed, the defense would have enough time to respond to the motion, but ultimately then he still has to have a hearing within 5 days in front of his assigned judge. So at this time, I don't think none of the rules have been followed in this case, so it would be the defense's position that he's being held illegally at this time.
Thank you.
Thank you, Judge.
All right. See you tomorrow.
See you at 1:30, Judge.
Oh, 1:30.